All right, good morning, everyone. Welcome to this round of Workplace Insights. I'm just letting y'all get in here. It is Erica Frank and Rashida Harmon again, coming at you live.
Hi, everyone. Happy to be here.
Rashida, I don't see your beautiful face. I don't know
You
if
don't
that's...
see my beautiful face? Oh, well,
It
let's
could be me.
something about that. How about now?
Let's see. Yeah, there you are.
Okay. Okay, let me hide our faces, though, even though they're great faces.
You don't like to look at yourself?
No, it's so distracting because then I'm just like gazing at myself. That's not good for anyone. Cool.
Great, so let's get rolling. So welcome everybody. Rashida and I are really excited to talk about this topic today, and we're presenting it in a very creative way because we were, brainstorming about, of course, diversity, equity, inclusion, and belonging are so important in the workplace, and we wanted to talk about the topic, but also, bring into the fold all of the existing laws and regulations that employers have had to follow for a long time in this area, and how we already have foundational principles to work from and how we can expand on them. So we're going to spend a good part of the presentation today teaching us all of, what are some of those requirements, what are some of those laws that we have to pay attention to, but really frame it in the sense of, when we talk about diversity, equity, and inclusion, part of it is casting a wider net when we're conducting our recruiting practices, right? Not to mention instilling and really focusing on, equity, inclusion, belonging with our existing workplace. Part of increasing a diverse workplace, of course, is our recruitment practices. So we are going to talk a lot about, at least at the beginning, some of those foundational principles, and we'll sprinkle in little insights as we go through, and then we'll end more talking a little bit more on the DEI topic without going into great detail.
Exactly right. And so, as usual, for anyone who's tuned into these workplace insights in the past, I'll be digging into the law and the regulations, and Erica is going to give us a lot of practical insights and real-world applications, and talking through some definitions and things like that. So I think this is a great topic. I'm very excited to launch into it. With that, let's see if I can advance this successfully. There we go. I don't know if you want to intro me, Erica. You don't have to.
Absolutely. So for those of you who not met Rashida before, let me introduce you to her. She is the Senior Counsel of Outreach and Education at now the Civil Rights Department. So for all of you, the commercial here is it's no longer the Department of Fair Employment and Housing. It's now the Civil Rights Department, and I'm finally getting it. It's good.
It's hard. Yeah, no, we're very patient. I know it's going to be a process, but yeah, CRD, Civil Rights Department, formerly DFEH. We love the new branding, and we're all collectively getting used to it.
Yep.
And I can intro you briefly, Erica, just by noting that Erica is a well-respected employment attorney with a passion for advising and educating employers about the complex workplace laws in our state. She's at Shaw Law Group as of counsel. Prior to that, she was general counsel and executive VP of legal affairs at the California Chamber of Commerce, along with a lot of other wonderful things. And she has a great deal of expertise in workplace employment laws, and we're very excited to collaborate with her.
Super fun. All right, so although we are attorneys today, we are not providing you with legal advice. Our intent with this program is to really provide you that general overview, 50,000-foot look at, what the laws and regulations say. Of course, contact your regular counsel before making any changes to your policies after listening to today's presentation.
Exactly right. And to sort of build on that, just because I'm representing a state agency, that does not mean I am establishing substantive policy or rights in this presentation. And of course, as Erica noted, this does not constitute legal advice. So really quickly, I'll launch into our mission just so everyone is aware of what CRD does. I just gave another presentation, and I know that there's some folks from that presentation here too, so you're getting a double dose of some of the same information. And for many of you, this will be repetitive from previous webinars, but in any case, our mission is to protect the people of California from unlawful discrimination in employment, in housing, at businesses, as well as state-funded and administered programs, and also protect them from hate, violence, and human trafficking. I won't harp on this much further, but as we've noted, we have changed our name from the Department of Fair Employment and Housing to the Civil Rights Department in order to more fully encompass the full scope of what it is that we do. We have many responsibilities. The first is to investigate complaints of discrimination, as well as cases of broader systemic discrimination. We facilitate mediation and dispute resolution involving civil rights matters. We enforce the laws by prosecuting violations in civil court. We issue regulations that implement the laws that we have jurisdiction over to provide greater clarity and guidance. We collect data on the pay and demographics of large employers' workforces, and we report some of this data on our website. And finally, we do exactly what I'm doing here today, which is we provide public outreach and education, as well as training and technical assistance on civil rights matters. Now, launching into the FEHA, what is it? It is a law codified in the government code. There are the citations for you. And the crux of what it does is that it protects people from housing and employment discrimination, as well as harassment, on the basis of protected characteristics. It also includes additional provisions that protect special populations that are not otherwise protected. So, for example, it contains the Fair Chance Act, which is a law designed to protect people with criminal histories in the hiring process. So even though being a person with a criminal record is not a protected characteristic otherwise, the FEHA does provide for these additional protections. And there are several implementing regulations that expand on the parameters of the FEHA, which we will be talking about in great depth today. Now, to talk through what these employment protected categories are, many of them are things that you might sort of anticipate would be on this list, things like race, color, ancestry, national origin, religion, age, disability, sex and gender, sexual orientation, gender identity and expression, medical condition, genetic information, marital status, and military and veteran status. And so what this means is that under the FEHA, an employer cannot discriminate against someone or harass them on one of these bases. Turning now to some pre-employment practices. The first thing that we want to talk through today is the duty not to discriminate. So high level, the law provides that employers have to recruit in a non-discriminatory manner. However, the regs also say that an employer can utilize recruitment practices designed to attract someone who is a member of an underrepresented protected class. And this really begs the question, how do employers create a work environment that is inclusive without engaging in discrimination in recruitment or in hiring?
So a lot of this comes down when we're really thinking about recruitment practices, language that we're using in our job postings, on our LinkedIn postings, Glassdoor, whatever we're using to recruit. We want to be mindful with the language that we're using so that whatever language it is, it's not suggesting that we are trying to exclude certain individuals from a protected class. And later on in the presentation, we'll give you some examples, and it actually can be quite tricky. Even if it's not intentionally done, it's easy to get sideways on the appropriate language to use.
Yeah, that's exactly right. And thankfully, the regulations do provide some guidance in terms of how to approach things like recruitment materials, job postings, applications, even guidance on like interviews. So we'll be diving into all of those things. I also wanted to mention that the regs specifically call out certain pre-employment practices around recruitment based on protected categories. And so one of those is the duty not to discriminate based on sex. Under the regs, it is unlawful to refuse to provide, accept, and consider applications from individuals of one sex unless pursuant to some kind of a permissible defense. And employers actually can't ask the sex of the applicant on an application form or pre-employment questionnaire unless the question is asked pursuant to a permissible defense, again, or for record-keeping purposes. And finally, an employer can't ask questions about childbearing, pregnancy, birth control, or familial responsibilities unless these questions are somehow related to specific and relevant working conditions of the job in question.
So just from a practical perspective, very rarely will there be a reason at the pre-employment stage that you need to find out what the sex of the individual is. There's qualified, with the BFQ, bona fide qualified, I would say, we'll get to it. I know the acronym of when it's okay. But for the most part, there isn't a reason to do so. So just don't. When you're in interviewing, or even in your, job descriptions, we need to be careful that we're not, saying, oh, someone offers, oh, I have like 5 kids, or someone during the interview is late and they say, I'm so sorry, I had 4 kids that I needed to drop off at, school. We're not going to be following up questions about that because we don't want any kind of indication or even a suggestion that if we don't hire this person, it was because through the interview process, we discovered, oh, this person has 4 or 5 kids or might be pregnant, and that's why we didn't hire them.
Exactly right. Turning now to employment applications. In general, you can't require applicants to provide photographs of themselves. And Erica, do you want to talk about why?
Yeah, so again, I mean, that is going to be where we are somehow going to be making decisions based on how the person looks. What color is the person? How does the person wear their hair? At the end of the day, it doesn't matter. And I know for a while there was a trend for applicants to put their photographs on there. Mm-hmm. And of course, it's hard not to, if we're on LinkedIn and recruiting through LinkedIn, and it's kind of becoming the new Facebook where all of a sudden you have all these connections that you never knew. And of course, people's photographs are on there. So don't request them. If they happen to voluntarily provide their photograph, there's really nothing you can do about that. So of course, don't ask for it.
Correct. And then in terms of scheduling matters on applications, employers are going to want to exercise caution when using any kind of online application technology that limits or screens people out based on their schedule. And similarly, this is going to be because it might have a disparate impact on people based on their religious creed, based on disability, possibly based on medical condition, and as a result is unlawful unless there's some kind of job-related, purpose or something that's consistent with a business necessity, and the application has to include some kind of a mechanism for the applicant to request an accommodation.
Fascinating, because this provision was added to the reg, gosh, I want to say a couple of years ago. With COVID, everyone's been in a time warp, and it was really just on the cusp when there was quite a bit of technology that was allowing employers to ease the burden of resume searching or application searching. And oftentimes it is going to be in those high turnover positions where recruitment is ongoing. The problem though is you got to beat the algorithms, right? And so a lot of times these algorithms are pulling or kicking applicants other than maybe they didn't fill out they left a place blank, or they didn't meet the algorithm structure, and as a result can have a disparate impact or discriminate against somebody from a protected class. We see this a lot when it comes with age. And remember, in California, if you're over the age of 40, you're considered old and protected, which I will refuse to believe. However, that is the case. So sometimes that even starts to come into play when you're asking about when did you graduate from college or when did you graduate from high school. Any kind of dates that are going to at least somehow suggest the person's age could create problems down the road. It's not to say that we can't, have these parameters of at least knowing where someone went to college, but we don't need to necessarily know when they graduated. And we need to be careful for using these software programs that we're telling the computer what we want to see and what we don't want to see in a non-discriminatory manner. Now, I am one of the least techie people you will ever find or meet, so I couldn't tell you how to do that. I just know from my tech friends that it is possible.
Yeah, and I think that's a good segue to this last point, which is that application forms can't be separated or coded either manually, electronically, or otherwise so as to identify people based on their protected class, unless there's some kind of a permissible defense here, or again, for record keeping or statistical purposes. So again, talking about algorithms and how they sort of code people, even if it's in like a positive way, like you can't positively code someone as being a person of color and sort of elevate their application using these sort of algorithmic approaches. In terms of pre-employment inquiries more broadly, you cannot discriminate based on a protected class, which we've alluded to now already. Any inquiries about an applicant's availability for work on certain days and times cannot be used to determine their religious creed, disability, or medical condition, as noted. An employer has to clearly communicate that an employee does not need to disclose any scheduling restrictions based on legally protected grounds, again, like religion or disability. But there are some things you can ask. And so the regs actually spell this out. They suggest that employers use the following language: other than time off for reasons related to your religion, a disability, or a medical condition, are there any days or times when you are unavailable to work? And so the regulations contemplate that this is a way to get at these sort of scheduling matters while also not running afoul of anti-discrimination laws.
So I love that the regulations actually give employers some direction, because you know that if you're following this direction, they can't tell you that you did something wrong. Well, they might be able to tell you, but it's going to be harder for them to justify it. What I really like about this example is it helps you in circumstances, let's say, where working weekends is really important. Now we have to be careful with Sundays, because for many individuals, Sunday is considered a holy day, in which case an individual doesn't work. Now that is totally permissible, right? We have to allow reasonably accommodate individuals who have a sincerely held religious belief who may not be able to work on a Sunday. So we want to make clear that we're setting that aside. We get that. Are there other non-protected reasons why? So, whatever the case may be, or just the person's like, I'm not looking for a job that I can work the weekends. We need to know that. So I really like this option. Now, of course, it's a vague to the extent that, a medical condition, what does that mean? And your lawyer might give you a variation of this question to ask. That's fine. If you're operating on your own and you're really wanting to make sure that you are utilizing the right language, this is a fantastic way to go.
Definitely. All right, let's talk a little bit about interviews, a fun topic. So, pursuant to the regs, an employer can't ask general questions about an applicant's disability or questions likely to elicit information about an applicant's disability in an application or pre-employment questionnaire. So again, the regs actually give us some examples, right? So some examples might be, do you have any particular disabilities? Have you ever been treated for any of the following diseases or conditions? Are you now receiving or have you ever received workers' compensation? Have you ever left a job or taken medical leave because of any physical or mental limitations? Have you ever been hospitalized? So these kinds of questions are not permissible in either an application or any kind of pre-employment questionnaire.
Now, what's, the thing about it, you can go to the next slide because we can talk about it, together. One of the things that I always like to tell employers when you get to that interview phase of the recruiting process, use that job description as your guidance, because as the next slide states, of course, part of the interview process is to not only meet the candidate in person, but determine whether they have the essential functions or the skills to perform the essential functions of the job. Resumes make somebody look 100% fabulous, the best thing you've ever seen, but really asking those direct questions related to the job is where you're going to really get the full picture of the candidate's qualifications. So a way to do that and to ensure that you stay on task and not get sideways a little bit with just our social norms of knowing someone, of asking how long, where do you live, some of those social introductory statements that we may say at a cocktail party, to have your questions listed out. And what I always like to recommend is, have a handful of questions that you're going to be asking every applicant, because it makes it easier to compare all of the applicants on an equal level. Now, naturally, you might ask some follow-up questions depending upon their answer, but with your pre-developed questions, you can ensure that they are related to the essential functions of the job, and it'll be a guide for you as you're going through the interview process.
Yes, absolutely. So yeah, as Erica said, you can inquire as to whether an applicant can perform the essential functions of the job. Yeah, I thought there was another slide after this. There isn't. So unless there's anything you want to add, we can move on. Cool. Now let's turn to recruitment practices. An employer is not allowed to engage in any recruitment activity that restricts, excludes, or classifies people based on a protected category. They also cannot express a preference for individuals or communicate or use advertising methods to communicate the availability of employment benefits in a manner that is intended to discriminate based on protected class. Some examples might be targeting specific protected categories in job advertisements. So, science lab seeks female scientists. That would not be permissible. They're seeking someone based on their sex or gender. Similarly, looking for fresh, youthful, and energetic camp counselors. Again, this sort of emphasis on youth that runs afoul of anti-age discrimination. An employer cannot decide to only interview candidates from certain desired groups. And this is your time to shine, Erica. Without business necessity.
My professional qualification, BFQ, right? Now, exactly. Of course, that is so limited, which I'm always even scared to bring up. I mean, I can give you, gosh, I don't even know if this is well, here's what it came to mind, models for clothing models, right? But even there, we have to be careful because we can't specify based on sex or gender, well, I guess now I'm getting into the weeds here, but we have to be careful. There has to be a legitimate business reason for which you are asking a particular individual based on a particular characteristic. And it can't be because female employees work better with, our clients. And it can't be because male employees are more reliable. It has to be that there is a very specific reason why a particular characteristic must perform this job. Now, with these examples that we've given to you, you can see how easy it is to get sideways with some of the questions, right? So looking for a fresh, youthful, and energetic camp counselor, in my mind, I'm like, well, I like to think that I'm fresh, youthful, and energetic, right? But I'm guessing they're not someone like myself. They're looking for somebody who is much younger. So that is where, gosh, I mean, maybe I can be as energetic as a 21-year-old, right? So that's one of intuitively you might think, God, I just want somebody who's very vibrant and has energy. I don't really care about the age. But we don't know that from just reading the language itself. Now, I can see also when we look at deciding to only interview candidates from a desired group, you're thinking, okay, but Erica and Rashida were talking about diversity, equity, and inclusion, and you started off talking about broadening our recruiting tactics. Like, wait a second, how am I supposed to create a more diverse workplace? And, you know, when we talk about casting a wider net, it's going beyond your norms, right? So if you are intuitively going to LinkedIn and asking your LinkedIn contacts, that could be why you're not getting candidates that are a little bit different from your norm. You know, seeking out some of those areas or broadening your sphere of influence. So for example, different bar associations, if you're looking for attorneys, you know, community colleges, different groups. Rashida, I don't know what you can add to that as far as other locations, you know, that you can go to advertise for your position.
Yeah, I mean, I think you've hit a lot of the major ones. Community groups, definitely professional associations, like you said, like specialized bar associations if you're hiring a lawyer, websites, you know, maybe even going to news sources or media outlets, nonprofits that serve and support underrepresented groups. And all of these places are great places to target and focus recruiting energy. And then, you know, to Erica's point, like, yeah, so if you want to increase diversity, what can you really do? In addition to sort of being intentional about your outreach, you can also look at hiring criteria. Things like, is a college degree really necessary for this position? Or is it fine if someone has equivalent experience but no college degree? Is a background check really necessary for this position or not? Because those kinds of things can sort of limit folks who come from underrepresented groups from you know, gaining access to these positions. The real crux of the matter being that barriers to hiring should be carefully tailored in order to actually meet the needs of the position. And then you can also review existing policies and benefits. Are they impairing employee retention or promoting employee retention? Are there opportunities for mentorship and professional development in these roles? So those are all things that you can consider when it comes to attracting and maintaining a diverse workforce.
And I just want to add, I do think, you know, one of the silver linings from COVID-19 and this new remote workplace and environment that we've all embraced, it has allowed us to cast a wider net. It has allowed us to reach into communities for which we may have not reached out to, whether it's because a commute is a barrier one way or the other, whether it's lack of a vehicle, lack of affordability of getting to work, childcare restrictions, whatever the case may be. Remote work has certainly allowed for organizations to broaden and cast a wider net and bring in other individuals from different communities, races, ethnicities that they may not have otherwise reached out for.
Definitely. I wanted to make the distinction now between positive discrimination and positive action. And first, let me just note that these are not legal terms. These don't come from the regs or the statute. But I did think it was important to talk through these things because this really gets at the heart of what it is this presentation is about. So positive discrimination is where a job applicant is receiving favorable treatment because of a protected characteristic. The favorable treatment comes at the expense of other folks, other groups. An example of this might be hiring a less qualified woman for a role instead of a more qualified man solely because we want a woman in this role. By contrast, positive action is improving diversity without impacting other groups. So, for example, maybe you have 3 equally qualified and competitive candidates, and so you choose the one who does have a protected characteristic, but this person is just as qualified as everyone else. Anything you want to add on this, Erica?
Yeah, I think this is such a great slide because it's one that it helps to clarify some of the confusion and challenge that employers have in this space, and making sure that we're not running afoul of what the law requires, but at the same time building a workplace that's community-based, that makes everybody feel welcomed, and that definitely reflects the clients that the organization might be serving, even if that is internal clients. So the less qualified woman for a role instead of a more qualified man solely on the basis of her gender, that is something that a lot of employers have been concerned about, and a lot of something that we have to be mindful of. And it's interesting because there were times where we would hear this, right? Of, well, does that mean that I just have to hire based on gender? No, it means you can find a qualified individual who meets the criteria that you're looking for. And if you haven't found that person, you got to keep looking. That's what that means. And seeking resources that can help you get to that individual. A lot of employers are utilizing recruiters to try and get beyond kind of your sphere of influence. It's not easy. It can be challenging. So it's a matter of being creative in your recruiting practices. And I know that's easy to say, but that is really the reality.
Exactly right. A quick word about documentation. If a job applicant takes legal action against an employer based on discrimination in hiring or recruitment, employers should be prepared to produce documentation of every step of the hiring process, including the job posting, including the resumes and applications that the employer received in response to the posting, and of course notes from all interviews, including who was interviewed, what happened during the interview, etc.
Yeah, so this is one of those important ones where keeping that documentation is a requirement under the law, but also being cognizant of how you take notes when you're conducting your interviews, and making sure that your notes cannot be construed in any discriminatory manner. And you might be thinking, like, what do you mean? Abbreviations that could be misinterpreted. Notes that mean something to you, but if somebody else read it, they could interpret it something differently. So be very careful. And I say that because there was a case eons ago regarding someone who was who interviewed for a position for which she was it was a counter position at a department store, and this literally was like in the 90s, so 100 years ago. But it was for the jewelry counter. She didn't get the job. She was Jewish and brought a religious discrimination case. And of course, I'm leaving out a lot of facts, but what I'm trying to get at is she was able to get before a jury because the evidence reflected a resume with notes from the manager that had JEW on it. Now, the manager meant jewelry experience, that's why they put JEW. However, that was enough to raise that question of whether or not a jury may find that there was religious discrimination. Now, of course, bad facts make bad law. There's a lot that goes more into that, but the moral of the story is take a look at what you write and see what would they mean standing alone without your brain filling in the blanks.
Yeah, that is incredibly helpful. I wasn't aware of that case, but
it's so old. I'll have to dig it up. Like, it's one of those things you can't forget, because it's just like, oh my gosh, it's mind-blowing for so many reasons. But yeah, long time ago.
That one will stick with me. Yeah, and then in terms of interviews too, we had mentioned that it's not permissible for an employer to just interview, for example, only Black women and no one else. And so having documentation of who you interviewed can assist the employer when it comes to things like that as well. Now let's talk. Sorry, was there something else you wanted to add, Erica?
I was going to say, before we switch, there's some questions in the queue related to the legal requirements that we were talking about. So I thought this would be a good place to dive in. So let's see here. So this is fantastic. So Rashida, the question is, if there is a federal agency that has an EEO office, may employees still go to the California Civil Rights Division to investigate discrimination claims?
I'm not sure I understand the question.
So I think what the question is an employee limited to just going to the EEO, or may the employee also go to CRD to file a claim?
Yeah, the employee can go to CRD to file a complaint, and they can sometimes cross-file with the EEOC if there's also a federal claim. Hopefully that answers the question.
Answers the question. So the Equal Employment Opportunity Commission is somewhat of the federal component or equivalent to California Civil Rights Division. They both enforce the civil rights laws, one on the federal level, one on the state level. They both have complaint mechanisms in place as well. Now, employers generally follow both, and whichever is more generous or more beneficial to the employer, if there's a conflict, that's what the employer should follow. In California, in many instances, California is more protective of employee rights than on the federal level. So that's where you really want to make sure that whatever guidance you're following is specific to California, so that you know if there's any distinctions you're following, the more, you know, beneficial to the employee position. Let's see. What about asking preferred gender pronoun on the application so we know the correct pronoun use?
That is such a tricky one.
It is a tricky one. So what are your thoughts, Rashida?
I mean, I don't know. I mean, as we noted before, like an employer can't ask a person's sex on a job application or something like that, and really has no reason to. I think what the question is getting at is that this is a way of sort of making non-binary or you know, make people feel like comfortable and safe. My understanding is that those things should not really be asked during an interview or on an application. I don't know if you have different thoughts, Erica.
Yeah, so this is a tricky one, as Rashida mentioned, because we know under like the transgender regulations, which we'll be talking about at another workplace insight, you know, the employer is you know, expected to identify the individual by their preferred pronoun. Now, with that being said, when we're here at this early stage, so far, my recommendation has also been not to put that or ask that kind of information on the application. That is something, as the interview process moves forward, that you can then start to determine, you know, what the proper pronoun usage is. But at this early stage in the game, it would not be something that I would recommend asking for on the applicant too, because at the end of the day, you're still seeking some kind of information that's going to reveal at least gender, right? Not necessarily sex, but gender, and that is protected.
Yeah, and also a person's gender expression, gender identity, those things are protected as well. So you just have to be really careful. I mean, Erica, what would you think if the employer themselves during an interview, for example, said as sort of a best practice, like, my name is Rashida, I use she, her pronouns. Do you think that that would invite such a response in an impermissible way, or do you think that that's like a good workaround?
You know, I don't necessarily, I think that one, I think it's fantastic when, you know, everyone has personal choices when it comes to identifying their pronouns. I think from the perspective of showing inclusivity and, you know, to invite discussion, I think it's fantastic. Although I don't think it should be a way as a workaround to find out or seek what gender the individual is. So if it's more of being showing a sign of inclusivity, 100%. If it's designed to try and tease out the gender of an applicant, I wouldn't go down that road.
Yes, I would agree.
Okay, so Mercedes had a question about what would be a relevant question regarding childbearing, pregnancy, etc. For the most part, really, the laws are intended and designed to protect individuals who may be disabled by pregnancy or postpartum, before pregnancy, postpartum, and to bond with the child after. It isn't something that you're going to want to ask about. Now, naturally, if we are conducting an in-person interview and you see the individual in person and is noticeably pregnant, you're going to know, but you got to keep that in mind too, to make sure that that obvious pregnancy is not going to interfere with your evaluation of the individual. If they can perform the essential functions of the job and the pregnancy is the only barrier, then if you choose not to hire them, that's for a discriminatory purpose. So you have to be very careful and set aside, the preconceived notions of, oh, well, she's pregnant, so we couldn't hire her. No. You can still hire her and work around the disability that she has. Of course, naturally, with remote work, we may not know. We may not see somebody, and we're not going to be asking that question to find out. So what if the customer requests a specific gender to service or facility to clean gender-specific areas? This is something common, Rashida, that a lot of industries do face, and it does speak to some extent to the bona fide occupational requirement that we were talking about. What are your thoughts on it?
I mean, I think exactly what you said. I think I'm reluctant to sort of make like a sweeping statement, but I think if it does involve the job in the way that you just expressed, then I think potentially it could be permissible. I defer to you though, because I've never actually seen.
Yeah, so like with a lot of things, I love to say it depends, because it does. If we're talking about a janitorial service company, naturally that company is going to hire a diverse, wide net of individuals, because there are a variety of companies and clients that they're going to serve. If a client has a preference that a employee that identifies as female clean the female bathrooms, the question then becomes, well, when are they cleaning them? Can the bathrooms be cleaned at a time when no one's going to be there? Is there a way within which that we can, make sure that the work is done without creating any discriminatory issues if we're now specific gender? Now, of course, if there's safety involved, if there's health or safety concerns, those are always going to be concerns that we have to keep in mind and balance, and goes to that business necessity. What is the business necessity of requesting a certain individual? So that's why it really depends. Now, if you think about in doctor's offices, there might be occasions where a female nurse is required for safety reasons, for a variety of legitimate business reasons. And again, we have to go back to that to really tease out when we can and can't have some decisions based on a protected classification without running into some kind of discrimination claim or practice.
Yeah, I mean, all of this stuff I think is really tricky and hairy, which is why we're doing this presentation. But I mean, at the end of the day, as you said, Erica, it's all going to be highly dependent on the individual circumstances of the job and the various considerations there. So as usual, the lawyerly response is always, it depends.
Yeah. And again, like Rashida said, these are very general questions, and each question might have very specific workplace situations that you need to speak with legal counsel about.
Yes.
Let's see. There was a couple of questions of an example of a bona fide occupational requirement. So for example, a church employee who has to be a member of the denomination to fulfill the job duties. Models or actors that need to show authenticity to perform their role. Now, again, that can be tricky as well, but those are just some examples. They're very, very rare. And in most workplaces, it's not going to come into play. Okay, let's talk a little bit now about equity, inclusion, and belonging.
Cool.
Big topic today. So we've laid down the foundations, right? Of, just some things that we have to keep in mind when we're recruiting, and why you know, it can be very tricky when we're instilling and really building upon diversity, equity, inclusion, and belonging in the workplace. Now, of course, it doesn't just start at recruitment. You know, that is one of those first steps. A lot of it happens as we are operating, as we are instilling workplace culture, as we are fostering working relationships within the organization.
Yeah, and so just to do some level setting to make sure that we all understand these terms, I love this quote from Verna Myers from Netflix. Diversity is being invited to the party, inclusion is being asked to dance, and then this follow-up, belonging is knowing all of the songs. That's from LaFawn Davis. And I think we define these terms further here. I also just want to make clear again that these are not terms that come from the statute, from the regs, but we nonetheless thought it was important to talk through these things just to make sure we're all on the same page. So diversity really speaks to the range of human difference, right? Each person has layers of diversity, layers of identities that make their perspective unique. It is about representation. Inclusion is all about involving and valuing human differences and seeing such differences as strengths. It is about actions. Belonging is a feeling of community with the people and the environments that instill connection. I'm going to turn this over to you, Erica, to talk through this.
Yes. You know, I am a very visual learner, and I had attended a conference, and the presenter had presented the visuals that I'm about to show, that we're about to show to you, and they just resonated so well for me that I found them very effective in articulating or trying to describe in greater detail what these terms mean. So obviously here we see that there's clearly levels of inequality. We've got two individuals standing below a tree, one individual who's in the red suspenders, you know, his side of the tree is, or her side of the tree is leaning towards them, making it easier for the apples to fall. This individual's side of the tree is more plentiful and bountiful of fruit, whereas the gentleman, or I keep saying gentleman, the individual on the right, it has the blue suspenders, and it's like, what's going on? How come the other guy is getting apples and I only have two on my side and nothing's falling? Like, this is so not fair. Clearly the individual with the red suspenders has an advantage over me because the tree is closer in distance to that individual and there's far more apples that can fall. Make things somewhat equal? Well, let's see. We both now have ladders, okay? So previously, the apple was just falling off the tree, and that was just not fair because the apples were falling on one side rather than the other. So now we're going to level the field to the extent that we're both going to have ladders that are going to allow us to retrieve the apples on our own as opposed to waiting for them to naturally fall. Well, yeah, we both have, these two individuals both have ladders, but what we haven't taken into consideration is the tree is still leaning more on one side than the other, and there's more apples on one side than the other. So of course, the individual with the red suspenders, it still has a greater advantage than the individual with the blue suspenders. They both have a ladder and they both have the same tools and equipment to retrieve apples, but one still has the advantage over the other. What they've been provided, they both have access to the tree, they both have a ladder, but they don't have equity. And here, this slide is what we mean by equity. They both have ladders, but the individual with the now red suspenders, the person changed, on the right side. In this way, that individual has access to the trees. Now, of course, there still is a disadvantage to the extent that the right side of the tree is not bountiful with the apples. However, as it relates to the positions and the circumstances of the two individuals, it's equitable. They both have the tools that they need to get to the tree. And then fairness. Now, of course, with fairness, we got to do something to the tree or go to a different tree or whatever. So, of course, you know, the picture changes a little bit, but the point that we're trying to make here with this slide is where the tree side advantaging one individual, we've now propped that tree up on one side and tethered it down on the other. So now the tree stands upright in equal distance from both individuals. Both individuals have the same ladder, right? Both individuals have access to the same amount of apples. Now, we know that this optimal picture, right? Like I said, all of a sudden this tree has equal amount of fruit all around it. And we have the ability to teeter it back upright, which isn't always the case, which is why we want to strive at least for equity. And that's where this diversity, equity, inclusion, and belonging comes into play. Now, the belonging component is not something that we oftentimes hear about when we're talking about DEI. And the reason that I like to talk about it is because it's not just enough to have a diversity, equity, inclusion purpose or desire or initiative within the organization. It's a matter of applying it and making sure that our diverse population feels like they belong, that the culture is embracing the diversity. And that can be very challenging. And something that I know is particularly so as we're in this remote work where folks can tend to be more in silos. They don't know what other members of their workplace are doing. They're not understanding what the organization may be doing as a whole. And it is very easy in this remote environment for our employees to start to feel isolated and alone. And so we have to make extra efforts as employers to make everybody feel included and belonging to this one organization that we're all working for and believing in.
So, what have we learned here today? Really, the end goal is to engage in recruiting practices that cast a wide net free from discrimination. Okay, that's really at the heart of what it is we're getting at today. We also want to diversify the workplace and workplace culture. And as Erica so eloquently just addressed, we want to, oh, there's a siren. There we go. Create a community where everyone feels a sense of belonging. And that's all we have. Are there any more questions?
There's just a few minutes. We do have just a couple. You know, many of these I'm going to encourage you to, you know, speak more with your legal counsel or with individuals internally so that you can get a very well-rounded answer to your question. Going back, though, to the gentleman who had a question about the EEO, we did get a clarification that some agencies like SBA have internal EEO, but are not sure they are independent, want to use California agency to get right to sue letter. So I think what we're talking about here is many organizations do have what they call EEO offices, and they use EEO in a very broad term. Mm-hmm. That is going to be your complaint mechanism and where you go to discuss any grievances. So that is what I'm guessing is what we're dealing with there. Let's see. I think that pretty much covers it. Casey, the PowerPoint, you should be able to download it in the GoToWebinar dashboard. There should be a chance it says handouts, so you should be able to get that Record retention. There was a question about record retention. So a lot of California statutes have specific record retention requirements depending upon the law. So there are a variety. In general, it's about 4 years is generally speaking. Rashida, I know that there are some specific requirements from the DFEH's perspective, but generally, I believe it's about 4 years for interviewing and whatnot, for interview and recruiting related documentation.
Yeah, that sounds right to me. I'm actually not 100% sure. That does sound right. I was going to say 5 years, but that's deep in the recesses of my mind. Not sure where I'm getting that.
Generally speaking, that is going to be the case. Again, each statute is going to have different requirements, but for the most part, that seems to be at least the general record retention parameters. All right, I think we are good here. I'd like to thank all of you for joining us today, and Rashida, thank you so much. Want to remind all of you, if we could just back up for just a second, the Workplace Wake Up with Jen is a fantastic podcast. She records one on a weekly basis, so every Wednesday you can hear Jennifer talk about all sorts of different topics. It's 15 minutes in length, and it's fantastic. Also, let's go upcoming webinars. There's a number here that we'll be offering, including our annual employment law update. So that is important because we will be talking about all of the new laws that we need to know about before January 1. So a very, very helpful and practical presentation for you all to join in here.
And I also wanted to plug that our next Workplace Insights is all about trans and non-binary issues in the workplace. And I know since there was that great question around what can I ask in terms of pronouns, those kinds of questions will be addressed more fully, and we can talk through those issues. And I don't have a date for that here, but just stay tuned, and it'll be on the Shot Law Group's event website.
Yes.
Very cool.
Everybody, well, thank you so much. I hope you were able to receive some good and helpful information today, and have a wonderful day.
Thanks, everyone. Take care.